Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation without any stop. On behalf of the petitioner, it is contended that the order of the District Inspector of Schools is patently misconceived. An order of suspension passed against a teacher principal of an intermediate college cannot remain in operation after 60 days unless it is approved by the District Inspector of Schools in writing. Such approval of the District Inspector of Schools does not in any way take away the power of employer to withdraw the suspension at any time for valid and good reasons. It is submitted that under the statutory provisions applicable, there is no requirement of any approval being obtained from the District Inspector of Schools before recalling the order of suspension by the appointing authority. So far as the second ground mentioned in the order is concerned, it is submitted that the petitioner was suspended under an order of the manager himself and therefore such order has been withdrawn by the manager. The suspension was not effected under any resolution of the board and therefore the complaint of 2 by 3 members of the board that no decision has been taken to withdraw the suspension is neither here nor members of the board that no decision has been taken to withdraw the suspension is neither here nor there. It is also pointed out that the order of the District Inspector of Schools approving the suspension dated 29/1/2010 has not been communicated to the petitioner till date, nor any opportunity was afforded by the District Inspector of Schools before approving the same. Shri V.K. Singh, advocate on behalf of the officiating principal, contends that the petitioner did not challenge the order of suspension effected against him nor the order of approval. It is stated that the issue as to whether the earlier suspension was effected under a resolution of the board or not has not been raised nor has been gone under into impugned order. He points out that the petitioner is involved in criminal case under section 420 IPC as is apparent from the copy of the first information report enclosed along with the writ petition. With reference to the judgment of this court in the case of Brij Raj Swaroop Bhatnagar versus District Inspector of Schools Ghaziabad and another 2001 for ESC 1574, it is submitted that such a principal should be kept out of the office. Lastly, it is contended that once suspension has been approved having regard to the seriousness of the charges, the Committee of Management could not have withdrawn the same unless the charged employee was finally acquitted of the charges levelled. The finding recorded in the impugned order by the District Inspector of Schools that suspension order cannot be revoked once it is approved by the District Inspector of Schools under Section 6 of the Intermediate Education Act without his approval is legally not correct. Under Section 16 of Act, the power to suspend the teacher principal is with the Committee of Management. Power to do an act includes with its ambit and therefore the appointing authority which has placed its employee under suspension can always withdraw such order of suspension for valid and good reasons.